Welcome, everyone. I'm Kim Browning, estate planning attorney here at Blue Chip Estate Planning. Thank you for joining us today for our Dirty Dozen webinar series. We're on part 4. You may not keep score, but your kids do. Today's topic is one that quietly plays out in families all the time. It's the way that parents treat their adult children differently during their lifetime, and what happens when those differences get tallied up after you're gone. We'll talk about real examples, planning strategies, and most importantly, how to prevent your family. Welcome, everyone, for being here today. This is our part 4 of our series, Dirty Dozen webinar series. I'm Kim Browning, attorney at Blue Chip Estate Planning. Today's topic is one that quietly plays out in families all the time. The way parents treat adult children differently during their lifetime, and what happens when those differences get tallied up after you're gone. We'll talk about real examples, planning strategies, and most importantly, how to prevent your family from fighting over your intentions. So let's get started. This is our agenda today, our roadmap. First of all, we're going to discuss what is fair may not be equal. We'll break down the differences between equal and fair. Number 2, the lifetime gifts versus inheritance. Will your kids keep count? Number 3, treating unequal children equally. We're going to be dealing with the inequalities in professions, their individual needs and capabilities. Number 4, loans made during lifetime, the forgiveness of those loans possibly, and clarity of those loans and transfers of money during lifetime. Number 5, special needs planning and protecting your special needs children without disinheriting them. Number 6, best practices for preventing sibling conflict. Number 7, we're going to go over case examples and real scenarios. And then we're going to have a Q&A session. So go ahead and please feel free to use the option to type in the chat, and I'll be checking the chats periodically throughout the webinar. So what is fair may not be equal. Life circumstances differ. Needs and opportunities throughout life are not the same. And fairness is subjective. Parents want to be fair, but fairness doesn't mean equal. Adult children may carry emotional baggage around, money that has been given during lifetime, certain gifts and attention. This emotional baggage plays out all the time in the courtrooms. I hear, well, that was mom's, you were always mom's favorite and you got preferential treatment during lifetime. So the goal for today is, how do we address this subjective fairness and unfairness with the children? An estate plan that doesn't consider that perception of the children and having transparency during lifetime will cause your children a lifetime of resentment. It could cost your estate money, and ultimately the worst thing is a breakdown in the family unit and the ability for the future generations to be able to have a good relationship. You want your grandchildren to be able to have good relations with the family as well. Special needs planning, do you have to disinherit your disabled child? We're going to go back a little bit to deal with the loans and forgiveness. I don't know how we skipped ahead so quickly. So one of the first things we have to address are lifetime gifts and the estate distribution. As you age and your children age, there are going to be situations where you want to be able to contribute to your children, and it can be a college tuition, it can be a down payment for a first home, it could be a loan, and it could be a wedding, it could be a lot of different things that possibly don't equate over the course of your lifetime. So understanding that these gifts made during your life, although it seems natural to the parent to be able to want to contribute and deal with these gifts and this what can be perceived by unfairness and inequality, we need to just address in our estate plan or make sure that the communication with the kids take place. So here's an example. You gave one child more during your lifetime through tuition, a house, a down payment, a business loan. But after death, you figure, well, I've lived my life. I've given to my kids as much as I could equally. They may not think that a division equally is equitable. So without the documentation, they're going to feel cheated and are going to have these resentments towards each other. The example here is Barbara gave her son $100,000 to start a business. She died. She left everything equally to her 3 kids. And then they were wondering, why didn't this equate in the estate plan? When I meet with my clients and there's this type of situation, and I always ask my clients, have you made significant loans during lifetime? Are there things that you want to equate? And when we are going to keep records of the significant loans, they need to be attached, they need to be in writing, they need to be set forth in and signed by the settler's actual handwriting, or at least signed and dated. Otherwise, there's going to be litigation. I can think of a particular case that went on in the courts in Macomb County for over a year, and it was over a loan that was gifted, and then the favorite daughter who received the loan went ahead and destroyed the records. So it's one thing that you keep records, but you also have to make sure that someone has access to those. And then there's the other issue of, what if you don't keep up with those records? If you record that there's been a loan and then you put your estate plan on the shelf and you don't update it, and your child ends up paying that loan back, but you don't bring your estate plan off the shelf and mark the date that the loan has been paid in full, then if you pass away and that remains on the books, then that child is going to have to then prove that they had either paid the loan or that it had been forgiven. So making sure that these records of these loans are kept, they're updated, and maybe shared with your estate planning attorney. I'd like to keep track of those types of items for my clients. Consider equalizing your gifts in your estate plan through a lifetime hodgepodge clause. This is something that can be done in the event that you do not believe that your family member is going to actually be in the position where they can repay the loan. These provisions in your trust are meant to add the value of the loan to your estate plan at the beginning, and then it can equalize through the distributions. Other hodgepodge clauses are available for individuals who have children of various ages. One example is, let's say you have 3 kids, one has completed their college education and you've paid for their entire college education. The second child goes maybe 2 years through their college, and then your youngest child is still in high school when you pass away. Well, if your assets are then divided into 3 separate subtrusts at your death, that oldest child did receive the full benefit of getting a college education. The middle child had 2 years paid, and then the youngest child, of course, has $0 paid toward college education. This is assuming that there's nothing in, a college savings plan. But the hodgepodge clauses, they're put in place to make sure that when the youngest child reaches a certain age, then the estate can be divided amongst the children, providing for this additional time for them to catch up so that they can enjoy travel sports, they can enjoy the education, they can enjoy the other things that the parents paid for, and they can catch up in age to their older siblings. In addition, and this is not just in place of, but in addition to things such as the hodgepodge clauses, and in addition to keeping records of these loans, clearly explaining your intent. Now, this can be done as a separate letter. If you, the client, is interested in, sometimes my clients actually make a recording of what their intent is. You can say, I love you all equally. However, I understand that I've provided for some of you during lifetime more than others, and this is what my intent is, and clearly stated in your own words and in your own video. But that's usually done with people who have a diagnosis that they understand that they need to get their affairs taken care of relatively quickly. Otherwise, we include it in the introduction of your trust, where we included in the same thing. I love my children equally, or I love my children unequally. I believe that having an inheritance is not a birthright. It is something that is it is something that is through a nurturing, loving relationship, and therefore I'm intentionally leaving this individual out or leaving them less money, because really ultimately it's up to you whether or not you want to leave your estate equally to your children. So your intent of why you're not equalizing, or you are equalizing, or you intend to equalize, needs to be put forth in the document, in the trust itself, or in a separate writing attached to it in your writing, or like I said, a video. An example of your children, maybe you love them equally, but they have separate needs. And this is, pretty clear. You have 2 children here. One is a doctor and the other is a hairstylist. Well, let's look at what's happened during the lifetime. The child who has gone through medical school, the question is, did you pay for this child and support this child while he has been attending undergraduate and graduate school, or did this individual have to take out loans, and did he do it all himself? Then you have another child who didn't go through the undergraduate, didn't go through graduate school. Maybe they've been living in an apartment on their own, self-sufficient, but they went to trade school. So what you've given to each of them during their lifetimes and in their career paths has been different. So this is not saying that the doctor did everything right and the hairstylist didn't, because this is really, I mean, it's their choice of what they want to do and as far as their career goes and what they want their income to be and their lifestyles. So without judging them, the first question is, did you, as a parent, contribute differently to let them achieve their goals? And is this something that needs to be equalized? And I can tell you that if you've put your son through school and medical school and supported that through the room and board and vehicles and just the maintenance and the expenses of that really long path of their career, that certainly has minimized what the family's eventual, estate for distribution is going to be. And it's certainly benefiting that individual in that his or her career path is going to be able to allow them to have a lifestyle that is possibly not going to be needing the inheritance once you're gone. So, in the same respect, the hairstylist maybe is happy living in an apartment, but is thinking, well, geez, you gave my brother several $100,000 in education and support over the course of 8 years of schooling, and am I going to get this equalization at some point down the road? So that's something that needs to be addressed. So dealing with the expectations is important, because maybe the daughter who's the hairstylist doesn't expect it. Maybe they're very happy for their sibling and supports their sibling, and that might be the family that you have, and maybe you've communicated this all throughout this period of your lives and their lives, and it's not going to be an expectation. But if you don't talk about it and if you don't address it during your lifetime, you don't want it to come up when you're gone and you're not able to actually speak for yourself. Okay, so this is, again, addressing that every family defines it differently. And I can't tell you what to do. All I can do is I can help discuss the situations. I can address what I've seen my different clients go through and help you steer in a direction that is going to best fit your individual family needs. Here we have unequal children but equal love. Again, an example that the parent left more to a daughter with a medical debt and children. So here it really kind of goes back to the other example. Brother's a successful surgeon. I'd like to say, but okay, brother's a successful surgeon, and then there was outrage and feeling of being penalized for his success. And this really does go back to your own personal opinion. Do you feel as though if at the end of the day, when you're gone, if you do not leave everything equal to your children, do you feel as though you're penalizing your successful child over your other individual, your child, for making their decisions? It's a personal decision, but it really matters on what your children's perception is and just keeping the peace between them. So being transparent, consider telling them while you're alive. And then here's another tool that we can use. They're incentive trusts, specific gifts. So we do gift during our lifetime for education and 529 plans, but tools in our trust can also be, well, we're going to go ahead and we're going to leave a bonus to our children if they pursue a higher level education. And if that's communicated during your lifetime, that your family actually values going to school, getting a higher education, as opposed to, going into the trades or starting something, a business or like something else right out of high school. That's something that you need to communicate with your kids so that they understand that if they choose that path, they may or may not have something down the road when you pass away. Now, again, this is all getting to, what are children's perceptions of your estate plan, and maybe it gets to the point where you think, well, geez, I'm not living my life and leaving my inheritance for my kids, just because they're going to be entitled to this. And I get all that, but I just am, this whole purpose of this webinar is just to try and keep the peace, to make sure that there's communication and understanding as time goes on, because estate planning is a process. It is something that you start at one point in your life, maybe age 18, you get powers of attorney put in place, you get a simple will, and then as you have children, you get a trust, and your trust changes. So estate planning is something that changes and evolves over time. So during this entire process of your life and your estate planning, keeping this in mind about how you address your children, it's a process. Loans and forgiveness. So the loans that you give to your children, lots of clients, they choose to forgive them. And that's a personal decision. If you want to forgive them, should you keep track of them? I don't know, but the whole point of this is that your kids know. And in the event that you become incapacitated and your kids get into your books, they're going to see it. So again, keeping the communication out there, keeping open communication with your client, with your children is important. But it's really up to you whether or not you want to forgive the loan or keep track of it. The example we have here is Tom loaned his daughter $50,000 and she never repaid it. After his death, her siblings demanded it to be subtracted from her share. However, no paperwork existed. And this is real. This is something that plays out in court, and it's really a difficult situation. So best practices, always document large loans with a promissory note if you expect to be paid back. And then in your estate plan, you can specifically state, I loaned $50,000 to my daughter, and I do not consider that as part of her inheritance. I forgive the loan. Or you can state that it must be counted against their inheritance. So this is the hodgepodge clause. So again, include a written directive to avoid the ambiguity. All right, so then we have the interesting situation of special needs planning. And having a special needs child, it usually is something that is your greatest worry, is how do I address his or her needs? How do I address who's going to be his or her guardian, legal guardian, or patient advocate, who's going to take care of that individual. And I see it too frequently that people will disinherit their disabled child because once they attain the age of adulthood, they might be on Social Security and they might need Medicaid benefits. And Medicaid benefits require, there's an asset limit and it's a pretty low threshold. And in order to make sure that they maintain their Medicaid benefits, because that's key to making sure that they're healthy and are going to continue to get their medical care that they greatly need, people are disinheriting their children. Well, there are certainly better ways than disinheritance, including establishing a special needs trust. So when you leave assets directly to a disabled child, it could disqualify them from their benefits. And in order to provide the support that they need, we should establish a special needs trust. Special needs trust can pay for things to supplement their life. The Social Security income that is provided to them should pay for food, and it should pay for housing. But the special needs trust can pay for anything in addition to that. So education, care, enrichment, travel, and more, including, clothing and everything else that they need to get by. So here Grace left $75,000 directly to her adult son with disabilities. He lost his SSI benefits and had to spend the inheritance before requalifying. Well, in reality, spending the inheritance before requalifying, you can actually establish a first-party special needs trust. But the disadvantage with the first-party special needs trust at that point is there's a state payback provision. So anything that's not spent for that individual during his or her lifetime can be subject to a state recovery, which means that the state of Michigan would then recover the value of the benefits paid out during that individual's lifetime. So it won't go back to another family member. Again, the goal here is preventing family fights. Steps to reduce conflict. Communicate your intentions early when appropriate. And, this can be just keeping open lines of communication with your family members. Hey, sister's going to go to medical school. Isn't that fabulous? Okay, that's expensive. How are we going to do this? Keeping open communication that certain loans are being taken out by the individual going through school, and understanding that mom and dad are going to supplement and be able to pay for housing expenses or whatever it is. Just making sure that there's open communication so that you don't have a misunderstanding, quite frankly. I mean, maybe that individual is going to take out a loan themselves to pay for food, and to pay for shelter, to pay for their expenses, and are loaning all of their tuition. You don't want that misconception. So make sure that the entire family is all on board with what's happening. Use clear documentation for gifts, loans, and decisions. Again, making sure that those ledgers for the loans that you expect to be repaid. So yes, promissory notes, and then make sure that you document the date, the amount of a payment, and then initial next to it. So keep a ledger. A lot of my clients will just keep a lined piece of paper with the promissory notes stating the loan that was taken out on August 12th, 2005 for $50,000. When was the first payment paid? When was the second payment paid? Until the loan has been completely paid back. Appoint a neutral third-party trustee if the sibling dynamics are fragile. So this is another planning strategy. Oftentimes, finding the right trustee of your trust is really important, and it's things that it's a topic that I can discuss with my clients. It can actually hold up the execution of a trust, because picking that person is a really tough decision sometimes. So a neutral third-party trustee doesn't necessarily mean a professional either. It doesn't mean you have to hire an attorney or hire someone who acts as a trustee regularly, like a trust company through a bank. If you want to appoint a family friend or another relative that isn't a beneficiary of your trust, then that third-party trustee can get involved and make sure that the trust is being administered properly and are going to deal with any emotional issues that come up through the administration. And here again, we talk about including an explanation letter, even if it's not legally binding. Well, I can tell you that when you go to court and you're administering a trust that is in question, there's certain things that the judge is going to look at. And one of the most important things that the judge is going to look at is what is that settlers or the grantor's intent? What did they intend? And having that explanation letter is so important. Okay, so I have a question here. I'm going to just take the question. Is there a way to avoid your children finding out that you did not distribute your assets to them equally? Oh, well, that's a really good question. So again, with the administration of a trust, when you pass away, how do the kids know who got what, when, where, and how? And that's something that I also address with my clients in advance. You can actually redact the trust, and redacting the trust means that, okay, so let's start with what the beneficiaries are entitled to receive. Anyone who is listed as a beneficiary in the trust, when you pass away, they have a right to receive a copy of the trust. That is part of the statute. So yes, they will receive a copy of the trust after you've passed away. They're entitled to an inventory, so they need to know what is in the estate, what is in the trust. And then they're entitled to an accounting, which means the money that's gone in and out of the trust during the administration period. So do the beneficiaries of the trust necessarily know who else is receiving assets through the trust and how much they're receiving? So if you want to redact, which means blacken out or keep private certain parts of your trust, you are able to do that. So you can actually state in your trust that you're going to leave 20% to this organization, organization ABC, and then the rest, residue, and remainder is to be distributed evenly to my children, and that 20% can be left private. So that's how you would avoid them knowing. And then another question, can you set conditions in your estate plan for when and how your children receive their share of the trust? For example, could I structure it so my child receives $100,000 at age 35, but if they marry or have children before then, I want them to receive $20,000 in increments. I guess that would be. Okay, so yes, you can put in all sorts of qualifiers with your distributions of your trust as long as they're legal. They have to be legal. So you can say as long as they marry, that's a positive thing. But if you say as long as they don't marry, you can't encourage them not to marry. Okay, and then, okay, I see that you've corrected your oops starting at the time of the event. But yes, you can go ahead and you can be specific as to how and why you want them to be distributed as long as it's illegal, as long as it's legal. Another thing that you can put into your trust is a no contest clause to discourage disputes. Okay, so recapping on what we've talked about, we've explored different scenarios. The lifetime gift to one child, and then that lifetime gift is not acknowledged in the estate plan, and we have sibling resentment and legal threats. And along this line, so lifetime gift to one child, another example that comes up quite frequently is for my clients that are aging, to be able to age in place, stay in the home without going into a nursing home. Sometimes a child will move in with them and maybe give up a career and maintain their separate home as well. So that caregiver child, although it might be perceived by some siblings that they've received a benefit by living with mom and dad, or they will say sponging off of mom and dad, and therefore, they've lived in the house, they haven't had to pay the expenses, they've received a lifetime, or received this gift during lifetime. So addressing caregiving is something that should be done as well. And keeping the open communication, or not acknowledging it in the estate plan that, hey, this individual's moved in with me, they've given up their career path for the past 3 years as I experienced these health issues. Maybe you gift them their house, or maybe you don't, but even explain, well, what really has been gifted to that individual. Or maybe you need to put some sort of estate plan document in place, like a caregiving contract. Maybe you don't just, leave it without any explanation, but a caregiving contract stating, yes, my daughter's going to move in with me and take care of me for the next 3 years. And in consideration for that, I am going to make sure that they're going to receive the benefit of the house, or I'm going to pay them as though I would have paid another caregiver. So I give a value of this caregiving, X number of dollars. So that's another situation of lifetime gifting that comes up quite frequently. The disabled child we talked about, please don't disinherit your disabled child. Make sure that the special needs trust is properly established for them. Unequal distributions. When you don't provide the explanation for them, then you're going to end up with your children becoming estranged from each other. We don't want to do that. And then a loan's not documented. We need to treat those as an inheritance or not treat them as inheritance. That's a decision that the parents make. But we want to avoid the accusations of favoritism and fraud. Okay, I have a question. How do I document gifts so that there's no confusion later? Again, you can document them in an attachment to the estate plan, or put them on a separate schedule. Just make sure that it is signed and dated by you. And then what if you can't remember exactly how much you've given over the years? Well, again, this is your estate plan. If you can't remember how much you've given over your lifetime, you don't have to. You can do your best to pull together what you want to equalize. And that's something that I can certainly work with you when you come into the office. We can kind of put it together and see what it looks like and compare it to the assets that you have and what your intentions are and your goals moving forward. This other bullet point, verbal promises of inheritance and no legal backing, lawsuits by the left out child. So this happens when certain things are promised to the child, or maybe they are disinherited. Maybe you have a falling out with one of your children, and I don't know, an example is, it's a bad example, but I have a client who has 2 daughters. One of their daughters married someone who then took her away, according to them, and they just now have a contentious relationship with their daughter, and they don't like how this new individual is help raising her child. So they've disinherited her, but they've started to make amends. And if you let them know, we're happy that you're back into the fold, back into the family, we're going to update our estate plan. And then if they pass away before the update, the verbal promises of the inheritance most likely are not going to be held up in court. You need to make sure that you actually update the documents, get things in writing. So be fair, be clear. The children keep emotional score whether you realize it or not. So the key takeaways really are fair isn't always equal, okay? You must be intentional about your decisions and document and communicate as much as you can. So if you remember nothing else from today, you know, just remember those things, keep open communication, and if you're interested, you can please feel free to set up a consultation with me, and we can talk about your particular situation. It is a free consultation. So thank you for joining me today. I don't have any other questions, and I hope that you enjoyed today's webinar, and I hope that this helps you keep peace in the family, and I hope that you look forward to our next Dirty Dozen webinar. Thank you for joining. Bye-bye.